Welcome to this explainer. Today, we're diving into the incredibly fascinating historical evolution of Canadian legal ethics. We're going to be tracking its journey from being a stagnant, almost non-existent afterthought in the legal world to its massive awakening as a dynamic, deeply critical field of scholarship. So, if you're curious about how professions actually regulate themselves and where our modern rules of conduct really come from, you are absolutely in the right place. Let's get into it.
Okay, so let's start with this paradox. As scholar Adam M. Dodek perfectly points out, for a very long time, Canadian legal ethics was basically viewed as an oxymoron. I mean, decades ago, if you looked at course offerings at law faculties across the country, legal ethics simply wasn't a priority at all. While specialized law reviews were popping up left and right for almost every other subject, legal ethics was practically forgotten.
The sheer depth of this issue is captured so well by Mr. Justice Iacobucci. He diplomatically described it as a subject not well represented in Canada. But in reality, it was a field characterized mostly by its sounds of silence, which is completely wild when you think about it. A lawyer might go their entire career avoiding, say, maritime law or a tax law. But ethical questions? Those are unavoidable. It's the applied philosophy of lawyering, literally the core of what it means to be a lawyer. Yet, despite that fact, it remained this woefully ignored subject.
And this massive gap didn't happen overnight, it built up over decades. Starting way back in 1957 with Mark Orkin's lone book simply titled Legal Ethics, what followed was just an astonishing era of quiet. The legal establishment apparently looked at that and concluded, yep, one book is enough. They were totally unbothered by the 1974 Canadian Bar Association Code, which completely failed to stimulate any serious thought. And honestly, here's the most surprising part. While the post-Watergate era in the U.S. unleashed this massive flood of self-reflection and mandatory ethics courses, the Canadian legal establishment just kept hitting the snooze button right into the mid-1980s.
Section 1. 2 Catalysts for Change. Shaking the Profession Awake. Now, obviously, this era of silence couldn't last forever. Something had to break the dam. Ultimately, it came down to 2 massive catalysts that spurred a staggering 1,000% increase in books devoted to the subject. First up, the 1987 revision of the Canadian Bar Association's Code of Professional Conduct. Because a bunch of law societies adopted it, it effectively created a sort of ethical Esperanto, a universal language that finally allowed lawyers across the country to engage in a national conversation. The second key event, a landmark 1990 Supreme Court decision called Martin v. Gray. What made the Martin v. Gray ruling such a game-changer was how it brought abstract ethics right down to reality. The case addressed the standard for what constitutes a disqualifying conflict of interest when a lawyer changes firms. And in a highly mobile labor market where lawyers were trading firms almost like fans trade hockey cards, this had huge real-world relevance. Suddenly, the entire legal profession had to care deeply about conflict of interest guidelines, and it sparked a massive outpouring of commentary and analysis.
Section 2. The First Generation. Descriptive Foundations.
So this sudden awakening ushered in what scholars now call the first generation of modern Canadian legal ethics. We're talking foundational authors like B.G. Smith, Gavin McKinjey, and Gordon Turruff. Now, given how incredibly little material existed before them, these authors quite understandably built heavily code-based descriptive reference tools. They organized their work right around the newly minted professional codes or statutes. If you are a practitioner on the ground with a specific problem about fees or client confidentiality, these books were absolute lifesavers.
But here's the catch. The core limitation of this first generation was exactly that. They were purely reference tools. Don't get me wrong, they were absolutely excellent at telling lawyers what the law was and how to navigate a specific code, but they completely missed the deeper why questions. They didn't really critique the system or step back to ask if the rules themselves were actually just or ethically sound.
Section 3. The Critical Turn. Asking why.
And that brings us to the intellectual climax of our explainer. In the late 1990s, the field finally shifted into true analytical critique. This was spearheaded by Allan Hutchinson's 1999 breakthrough monograph, Legal Ethics and Professional Responsibility. This wasn't just another rulebook. No, Hutchinson boldly called for a major shift away from mere professional regulation and toward deep personal responsibility. He famously rebuked the profession's heavy reliance on codes, arguing that rules are really just a starting point and that leaning on them too hard actually provides a pretty misleading picture of true legal ethics.
Hutchinson's core argument contrasted 2 very distinct models of lawyering. He completely rejected the traditional hired gun model. The zealous advocate relying on a rigid adversary system and strict conformity, which ultimately results in a total loss of personal autonomy for the lawyer.
Instead, he championed what he called the hired hand approach. In this model, lawyers and clients actually engage in a political dialogue to find a mutually viable way forward. It's all about blending context, pragmatism, and above all, personal responsibility. But Hutchinson recognized a really important reality. You can't just tell practicing lawyers to change overnight. The root of the problem actually starts in law school. So to fix what he viewed as an ethical disease, he argued that law schools must embrace an educational dialogue. Instead of just training students to think like a lawyer and stripping away their individuality, schools should encourage them to think like who they are, bringing their own diverse backgrounds into the ethical conversation.
Section 4. The Global Context. Finding a Canadian Voice.
To truly grasp where Canadian scholarship needs to head next, we really have to place this whole evolution into a global context. Historically, the field has suffered from what scholars call Anglo-American confusion. For the longest time, Canadian legal ethics just heavily relied on foreign sources. I mean, when Mark Orkin wrote his book in '57, he leaned massively on lectures given by Sir Thomas Lund over in London. But here's the thing, the Canadian legal profession isn't just some clone of the UK or the US. Tradition and legal culture in Canada create very unique problems. And that means there's a pressing modern need to develop uniquely Canadian ethical solutions, rather than dangerously relying on wholesale copy-paste from abroad.
So looking forward, where do we go from here? Well, international scholars looking at the legal profession, like Boon and Levin in the UK, have actually identified a set of modern forces as the next great catalysts for ethical change. We're talking about massive factors here: the increasing specialization of lawyers, the routinization of legal work, the rise of alternative dispute resolution, and of course, rapid globalization. These forces are fundamentally altering the climate of practice every single day.
Which leaves us with this final, really provocative question to consider. As lawyers are increasingly forced to confront these complex issues on a global stage, will forces like globalization, specialization, and alternative dispute resolution finally force a true, uniquely Canadian ethical reckoning in the modern practice of law? The framework is finally there, and the silence has definitely been broken. But the deepest questions of why and how we adapt next are still being written. Thank you so much for joining me for this explainer, and remember, keep questioning the rules.